Hi, everybody. Welcome. It's True Crime Wednesday. Hope you're all doing well. Sorry I wasn't with you last week. I had a good excuse. My daughter and son in law were here visiting. You all who've been following me for a while know that we moved back to Central Oregon recently. And that was in part because my daughter and son in law are planning to move here from LA. For my daughter, it's moving home. So they were here kind of scoping out rental properties, and we had a great long weekend together, did a little outdoorsy stuff, did a little kayaking. They took a big long hike, and in general, just kind of enjoyed Central Oregon in the summer. So, but it was great to have them home. But those of you who also follow me on social media have some big news, know that I had some big news because I got the real deal. I received my advanced author copies of the book, and I am so excited because it is beautiful. Pegasus Books has done a great job, and they did me proud. A few people have gotten, who are advanced readers, have gotten their copies and have posted the first few Goodreads um, reviews. And Amazon reviews are not possible until the 24th when the book actually ships and hits the shelves. So Barnes and Noble has been offering a discount on pre-orders for the book for anybody who's interested. I'll drop that in our links so that you can go there if you are interested. And that runs for from tomorrow until the 6th, so the 4th through the 6th. Barnes and Noble is offering discounts on pre-orders, and there's a discount code I'll put in the show notes. And things are just running along apace. The book releases officially and will ship to anybody who's pre-ordered on the 24th. And on the 26th, I'm going to be in the Portland area doing my first book signing at Powell's Books. For those of you who might not be familiar with Powell's, it is this amazing, the largest independent bookseller on the West Coast. I think maybe even west of the Mississippi. It's enormous. It is one whole city block, 3 stories tall. In downtown Portland. They also have an annex in Cedar Mill on the southwest side of Portland, which is where I will be. And it is an amazing honor to be invited to present and do a book signing at Powell's. Not everybody gets invited, so I'm really excited about that. I also have a couple of other book signings lined up in Central Oregon, one in Bend and one in Sisters. And my publicist is working overtime, publicist from the publisher, from Pegasus, working overtime on some new opportunities. So we'll keep you advised as we find out more about what might be happening for appearances, book signings, and more information about the book. Thanks to everybody who got an advanced copy and who's ready to post a review. And anybody who posts a review will be sending swag to you. So please be ready to post those reviews on the 24th. So we have a lot to talk about because we missed last week. So we have 2 weeks worth of things to catch up on. One thing before we get started, I wanted to mention is we had another school shooting in our country today. For those of you who might not have heard, there was a school shooting in Georgia. A 14-year-old boy is in custody, and 4 people were killed in the shooting. So please keep those folks in your thoughts and your prayers. please lift up victims um, and also think about how our country is coping with gun violence. Um, I don't want to get on a soapbox, and we don't get political here, but I think it is important during this election cycle that you consider the issue of gun violence when we're talking about um, some major electoral decisions to be made. So I generally do not post anything particularly political on my socials, except on Twitter. So if you want to know my political opinions, you can check it out on Twitter. Otherwise, we keep it sort of nonpartisan here. We talk about true crime, about law, and and where crime and law connect. And we talk about stories having to do with the law and law enforcement and true crime cases. So we have a lot to get to. So I'm going to dive right into it. First of all, a little bit of news on the Karen Reed case. Karen Reed is the case out of Massachusetts. Karen Reed is accused of murdering her boyfriend, Boston police officer John O'Keefe, by backing her car over him. She was tried, and her trial resulted in a hung jury and a mistrial, and she is scheduled to be retried in early 2025. Recently, her attorneys filed a motion to dismiss her case because it came to light that at least there were 3 counts that she was accused of, and it came to light that the jury actually acquitted her on 2 of the 3 charges. But when they filled out the jury verdict form, they didn't indicate that on the jury verdict form. They reported that they were hopelessly deadlocked, and the judge did not inquire about whether or not they had reached a verdict on any of the counts, and simply assumed it meant all 3 counts. And unfortunately, it wasn't until after the mistrial had been declared that that information came to light. So the defense had filed a motion to dismiss her case, or in the alternative, to dismiss those 2 charges. The judge declined to do that. That is the decision that came out recently. The Judge Canoni, just declined to do that, and left it up to them to appeal that decision if necessary. So undoubtedly, they will appeal that decision. I hear that I'm already getting a little scratchy. We've had about 2 weeks of really beautiful weather, very clear, but we do still have a lot of wildfires in central and southern Oregon. And unfortunately, the smoke from those fires sort of funnels right up the east side of the Cascade Mountains. And so we this morning woke up to terrible smoke in the air from the wildfires. So I'm a little scratchy. Everybody around here is a little scratchy. I'll try and drink water frequently, and we'll try and get through it together. So bear with me. I am sorry. There are some interesting developments in Massachusetts that sort of dovetail into the Sandra Birchmore case. And I'm going to talk more about Birchmore in a few minutes, but it will be interesting to see how how things that happened in the Reed trial may come to light in Sandra Birchmore's case. We'll talk more about that. We also, I was following the Tellus case out of Las Vegas. That was really a fascinating case. Mr. Tellus is or was a lawyer. He was the public administrator, the elected official who was responsible for handling estates of people who died without a will. He had a staff of 6 or 8 people who worked for him, and there were some conversations between staff members and an investigative reporter for the local newspaper about concerns of things going on in the office that were that were a problem. That there was a lot of dissent in the office. There was an extramarital affair going on. There also were instances where Mr. Tellus says that he was rooting out some corruption and some instances where the staff were sending sales of real property to a particular real estate group in return for what may have been kickbacks. That's at least what he contends. So what we know is that that a person dressed kind of like a landscaper, dressed in a long sleeve sun protection, bright orange sun protection shirt, a big straw hat, and some fairly distinctive Nike shoes, was seen on Ring doorbell camera approaching the reporter's home, moving to the side of the home, and then the man comes home, there's a scuffle. It's not really clear what's going on because it's sort of behind some bushes, but there appears to be a confrontation. The person dressed in the hat and the shirt then comes back down the sidewalk and walks away. Then a block later, Mr. Tellus is seen getting into his wife's SUV a block or two away from the reporter's home. Later, when the autopsy is done, they take samples of the reporter's nails and nail clippings, and Mr. Tellus's DNA is found under his nails. So Mr. Tellus from the beginning has said, this is a setup, I'm being framed. It's a little hard to believe. Evidence, the cut up hat and the cut up distinctive Nike shoes are found in his home, actually hidden under a recliner couch. There's a lot of suspicious coincidences in the case. And so after about a week of trial, his defense, his attorney put on several defense witnesses. And then Mr. Tellus decided to testify. And it was somewhat unusual, and we'll talk about why I think this happened. It was an unusual request. The defense asked that Mr. Tellus simply be able to get on the stand and give a narrative rather than having his attorney ask him questions and answer questions. Now, typically, the better approach is to have an attorney ask a question and the person answer that question so that the defendant is not simply getting up there and potentially incriminating themselves by a slip of the tongue or going into some area of inquiry that the attorney wasn't really interested in or didn't think was going to be helpful. But instead, what happened was Mr. Tellus got up on the stand and gave this rambling narrative. And a lot of people wondered why they would do that. And I think the simple answer is that Mr. Tellus's attorney is an officer of the court and cannot be in any way seen to suborn perjury or to condone their client getting up on the stand and not telling the truth. And if there is any risk of that, this is the better course for the attorney. It's certainly not better for Mr. Tellus. And I'm certain that they told Mr. Tellus that he was better off not getting on the stand and not attempting to argue for this huge conspiracy to incriminate him. He didn't take their advice. He got on the stand. He gave this very long, rambling, sometimes hard to understand narrative about what he believed happened. And then the prosecution got to cross-examine him. And the prosecutor in that case is really an excellent trial lawyer to begin with. And the prosecutor knew this case inside and out. And so every time Mr. Tellus came up with an idea, he would shoot it down by saying, yes, but what about this? What about that? What about this? Was this person also involved in the conspiracy? What about this person? Were they involved in the conspiracy? Until Tellus really started to look absurd. I thought that it was interesting that the jury took much longer to decide this case than anyone expected. They actually took 1.5 full days to somewhere around 10 hours of deliberation. So that tells you that they were being very deliberate and looking at all of the evidence. So, but ultimately they returned a guilty verdict. And so I believe he is set out for sentencing, and I didn't look that up. So if anybody knows, you can throw it in the chat. Otherwise, we will. I'll look it up. He then promptly gave an interview to a TV station where he once again professed his innocence and went through this, sort of harebrained discussion about a conspiracy. And believe me, he did not do himself any favors with that interview. So it's unfortunate that he's just continuing to sort of dig his own grave, really, literally. He's sort of digging his own hole. So that is unfortunate. But, there is a point at which the client gets to make that decision, even if their attorney believes it is not in their best interest. So they absolutely were entitled he was absolutely entitled to get on the stand and give that narrative. I was just thinking about a case I had where a defendant insisted on getting on the stand and really and quite unfortunately sunk his own boat, which happens more often than not when somebody gets on the stand. So the next case I want to talk about is Sandra Birchmore. So let me give you a little bit of background on this case. It's a case that not everybody may be as familiar with because people in the case were just recently charged. So let me just give you a little bit of an overview. Sandra Birchmore was 12 years old when she applied for and joined an Explorer Scout unit. 20 years to life for Tellus. Thank you. Thanks for that. Sandra Birchmore was a 12-year-old who was really interested in law enforcement and joined an Explorer Scout post to explore a career in law enforcement. And a lot of organizations have Explorer Scout units. A lot of law enforcement When my husband was a search and rescue volunteer, they had an Explorer Scout post that was part of search and rescue. A lot of fire departments have Explorer Scouts. A lot of organizations have Explorer posts. A lot of military organizations have Explorer posts, and they're all aimed at allowing young people to explore, hence the name, a career in that particular field. So when Sandra Birchmore was 15, one of the police officers, Matthew Farwell, was one of the instructors for the Explorer Scout. He took a particular interest in Sarah, and he spent a lot of time with her. He met her at the library, helped her with her homework, and in general did an awful lot of grooming. And then when she was 15 and he was 27 and in a position of authority, he began a sexual relationship with her. In Massachusetts, that is considered statutory rape because she was under the age of consent. And that relationship continued on for several years. In February of 2021, when she was 23, she was found deceased in her home. And the medical examiner, based on input from the police investigation, ruled it a suicide. So for the past several years, Sandra's family have been trying to get officials to reopen her case. They hired an independent medical examiner, and that independent medical examiner said her death was a homicide made to look like a suicide. Sadly, she was pregnant with Matthew Farwell's baby. The day after she died, Matthew Farwell's, I'm not sure how it's pronounced, Farwell, I guess, his wife delivered their third child. What we know from a huge load of text messages that were recovered was that she was texting him. She was telling him that she expected him to be involved with this child. She wanted his name on the birth certificate. And she wanted him involved with the pregnancy, attending appointments. And he was hesitant, obviously. And she then said, well, if you're not going to do that, then I will tell your wife about us. There were several people who knew Sandra and were concerned about her relationship with Farwell and actually reported it to leadership in the police department. Now, the interesting thing about this is that the town of Stoughton, I think I'm pronouncing it right finally, the town of Stoughton is a suburb of Boston, just near the town of Canton. So I'm turning my alarm, my sounds off on my phone. I just heard it ding. Interestingly enough, Stoughton and Canton are nearby one another and are neighboring suburbs outside of Boston. And it was when the issue of Sandra's death came up, it was the Canton Police Department and Trooper Michael Proctor from the state police that were put in charge of the investigation. That is the same police officers who have come into question in the Karen Reed case. So there has been, both online and in print, some speculation about how widespread the corruption is in the police departments in the area surrounding the Boston area, the suburban Boston. And so, interestingly enough, it was the feds, once again, who got involved in the investigation. So just like the Reed case, where the FBI got involved, the FBI has been involved in Sandra Birchmore's case. And it is actually the federal attorney general who has brought criminal charges against Matthew Farwell. I don't think his is the last prosecution we're going to see in this case, because there were at least 2 other officers who admitted to having sexual contact with Sandra Birchmore when she was underage, and that also have admitted to this grooming activity. So I think we're going to see other prosecutions. Whether they will be federal prosecutions or not is a question. But Farwell has been prosecuted under the federal law. And the potential is life in prison to the death penalty are the potential sanctions. So, but the federal government appears to be investigating law enforcement in that entire area. So one of the things that's unfortunate about it being a federal case is that the feds do not allow cameras in the courtrooms. So there's no way for us to be able to view the trial that will happen with Michael Farwell. One of the interesting questions is at least one of the potential expert witnesses in Birchmore's case is a state investigator whose name is Nicholas Guarino. He testified in the Reed case. And in the Reed case, he was the person who gave all of the information about the cell phone dumps. Now, interestingly enough, when he attempted to extract text messages from Sarah Birchmore's phone, he said there weren't any. But interestingly enough, the FBI was able to uncover 30,000 text messages that went back and forth between Sandra Birchmore, Matthew Farwell, and others in the Stoughton Police Department. So now the question is, does this information impeach Guarino in the Reed case? If he's called to testify again in the Reed case, can his failures in the Birchmore case come in against him in the Reed case? So that's sort of an interesting little twist. We do know that Michael Proctor, who has been put on unpaid leave while the state investigates him and his poor performance as a state trooper, we know that he was the lead investigator in the Birchmore case. So we know that his credibility is going to continue to be undermined, both in Birchmore and in Reed, in the retrial of Karen Reed. So I'm very happy to hear that Sandra Birchmore, that her case has been reopened, that Farwell has been charged, and that it appears that she's going to see some justice. So I'm happy to see that is coming. So we have about 100 people in chat. Thanks for joining us tonight. Please take a minute, hit the thumbs up, and if you are not a subscriber, please consider subscribing to the channel. And we'll move on now to a couple of other cases that have had some developments. Um, Brian Kohberger, there was a hearing on the defense's motion to change venue. The Kohberger case is the University of Idaho case from Moscow, Idaho, where um, 4 college students were murdered in their off-campus home. Brian Kohberger was linked to the crime scene by DNA found on the sheath of a knife that likely was the murder weapon. And he left the area and went to Pennsylvania, where he was from. He was arrested over the Christmas, New Year's holiday at his parents' home, extradited back to Idaho, and has been awaiting trial now for more than a year. He has a really good defense team. I also am not super impressed with the prosecutor and his team, so I don't think his conviction is a slam dunk. We recently had a hearing on the issue of change of venue. Those of you who are familiar with Daybell know that in the Daybell case, Judge Stephen Boyce agreed that there was no way that Chad and Lori could get a fair trial in Fremont County, which is a very small county in rural eastern Idaho. Similarly, there has been incredible amount of news coverage. And the defense team presented some pretty staggering statistics. And I didn't make notes of them, but their point was, yes, everybody all over the state of Idaho has heard about Brian Kohberger and the Kohberger case. Yes, there has been mass saturation. However, because the population of Boise is so much larger, it is possible that even if only 10% of the population in Boise have never heard of Brian Kohberger or the Kohberger case, or have not formed an opinion about the case, even if it's only 10%, 10% of 400,000 people is a lot bigger jury pool than 10% of 20,000 people that are in Moscow, Idaho. I'm using rough numbers. So I think that the judge is going to grant the change of venue. There are a lot of other creators out there who say they don't think that that's the case. They don't believe that the judge will grant it. We'll see. I think that they put on a pretty darn persuasive case for granting a change of venue motion. And, Judge, can you believe? John Judge is his name, said he was facing making one of the most difficult decisions in his judicial career. So I think he's not taking it lightly. He took it under advisement. He wanted to read all of the survey material. He wanted to review all of the testimony that was given during the trial or during the hearing on the change of venue motion. And he wanted to look deeply at the case law. So I expect, I'm a little surprised we haven't gotten a decision yet, but I expect that we'll get one very shortly. You might recall that trial is not set until June of next year. And of course, the Latah County, which is where Moscow is, will have to coordinate with Ada County to set a firm date. Brian Kohberger has waived his right to a speedy trial. We are nowhere near the top end of a lack of speedy trial, even with a waiver. So I think we're going to see the judge grant that motion. We're going to see Latah County work with Ada County to schedule a court date next summer. And I have to say, I attended both Lori Vallow and Chad Daybell's trials in Boise, and I thought that the Ada County Court staff did a phenomenal job. Their court coordinator, their court manager did a fabulous job. They were very organized. They were very they were very good at managing the crowds, but they were also very cognizant of making sure victims' families were taken care of, and that that both Lori and Chad were going to get a fair trial. They were very cognizant of protecting the jury and keeping the jury isolated from any outside interference. So I thought they did a really good job, and I think that the people in Latah County would be very impressed with how Ada County runs the Kohberger case if, in fact, the judge orders it moved. So, oh, and then I know that y'all want to talk about Sarah Boone. Wow, some stuff's happened with Sarah. So you might remember that the judge in Sarah's case, after she asked to fire her 8th attorney, said, "Miss Boone, this is a problem of your own making. You don't appear to be able to get along with anyone, and I am construing your behavior as a waiver of court-appointed counsel, and I am not going to appoint you any more court-appointed lawyers." The judge also said, laid out in a very detailed order with all of his findings, that's very appeal proof, all of his reasons why, and also said the trial will go forward in October, and you getting a different attorney, even if you are able to hire one, will not convince me to move the trial. So Sarah Boone then started working hard on getting her discovery, and we had several hearings about whether or not she could be handcuffed during the trial, whether or not she had all of her discovery, how the jail was handling giving her access to her discovery. We had a lot of hearings on handwritten motions that she was doing, and the judge was very patient but very firm with her on a number of things. He also was very strict, very straightforward with the jail, kind of saying to the jail, this person is pro se, they need access to their discovery, and really also holding the jail responsible. But the judge pointed out it has been over 4.5 years that this case has been pending. So the next thing that happens is that Sarah puts out, and I didn't clip it to show it, but it's out all over the internet. She sends the judge essentially what amounts to an advertisement for an attorney. And she asked the judge to put it up in the courthouse where other lawyers might see it. Well, of course, it goes viral. Everybody all over the country is talking about it, including Vinnie Politan from Court TV. And in the process of talking about it, he then has some conversations with some lawyers who say, gosh, I wish I were in her jurisdiction. I would represent her. And so lo and behold, out from the woodwork comes a lawyer from Pensacola. Now, us folks on the West Coast may not really understand the geography of the state of Florida. First of all, the state of Florida is huge, and driving north to south is a 7 or 8 hour drive, and there is a huge geographic distance, as well as a huge economic and cultural difference between northern Florida and southern Florida. And South Beach, Miami is glitzy and lots of money, and Fort Lauderdale, lots of money. But you get up north and you really are looking much more, they're much more like Alabama than they are like South Florida. That said, this attorney from Pensacola, which is up in the northern panhandle of Florida, right up where the Gulf makes the curve, that attorney from Pensacola has taken Sarah's case. Um, he is a very experienced lawyer who has taken somewhere around 100 cases to trial. That's a lot, because such a large percentage of criminal cases settle. So to have tried that many cases, it's a lot. He's got a lot of experience. It is interesting that Benny Politan had him on his YouTube program today, I believe. It may have been yesterday. And he's very well spoken, and he essentially said, "I believe that she has a right to an attorney and has a right to a fair trial, and I have agreed to represent her." He says, "I am not doing it pro bono. I have told Sarah that at some point she will owe me, and I may or may not be able to ever collect, but not being able to afford me should not be a barrier to her having adequate representation." So I thought that was really interesting. So following his filing a notice of appearance, now her trial is due to start uh, at the beginning of October. I have to look up the exact date in my notes, because I get it mixed up with another case. Where did my little pink notes go here? But she is set for trial, and the judge has been very, very clear. They must be on the floor. They are. Excuse me. Had to get my little hot pink sticky notes. The judge was very clear in his order that he was not going to allow her case to be continued. So, and sure, is it not in my, oh, there it is. 7th of October is when her trial starts. Yes, you're right, Jennifer. Thank you. As I'm fumbling. Thank you, Jen. Yeah. So the 7th of October is when she is, her trial is going to start. Now, this new lawyer went back to court and said, "Judge, I know your order said no continuances, but I just got on this case, and here's my dilemma. My dilemma is that I've had conversations with Sarah, and I believe that she has a colorable defense of battered spouse syndrome or battered partner syndrome. But I have to declare that to the prosecution by the 7th of September, 30 days before the trial. And my problem is that I need to consult with some experts who need to do some investigation and some evaluation of Sarah. And I can't get that done by the 7th of September so that I can file my notice of intent to present that defense. And so I'm asking for a short set over to get the evaluations done and be able to give the appropriate notice to the prosecution. That seemed like a wholly reasonable request. And if it were not for the fact that Sarah Boone has behaved so poorly and has shot herself in the foot, and that if it had not been for the fact that there have been 16 continuances at the request of the defense, And not for the fact that this case is 4.5 years old. Um, the judge might have considered it. However, the judge said, no, I've given you that deadline. I specifically said in the order that hiring her own counsel would not trigger my allowing additional time. The date is the date. And I think that Mr. Owen, James Owen, who is the attorney, expected that that was going to be the outcome. I would have expected that had I been making the request. But he needed to make the request because it's part of the appellate record. So if at some point there is a discussion or an appeal about how Sarah Boone didn't have an opportunity to present all of her defenses, he has to have made the request for there to be extra time for him to be able to appeal that issue later. Sorry, too much smoke in the air. So he is, he had to make the motion, even though I don't think he was very surprised that the judge denied it. He appears to have a good grasp already of the facts, and I think that he is a very experienced lawyer, and he'll be ready to go to trial on the 7th of October. He will figure out a way to go to be ready. Is he going to be successful? I doubt it, simply because there is an incredibly incriminating amount of information. Most specifically is a video that Sarah Boone took on her own phone of Jorge in the suitcase, begging her to let him out, and her taunting him while he's curled up in the suitcase saying, I can't breathe. The link to that is in our show notes. Please view it with caution. Trigger warning, trigger warning. It is very hard to watch, knowing that Jorge died in that suitcase. So if you choose to watch it, please be aware it's hard to watch. And I think that is going to be very difficult to refute with a battered spouse defense. Now, on that video, she does say, that's what I feel like when you choke me. That's what I feel like when you know. So she does make that statement. And I think that's what the defense is going to latch on to, that she was likening it to him, to him choking her. I think the difficulty is going to come with the battered spouse defense is generally, I was so conditioned by his abuse, and I was so afraid of him as an abuser that I felt I had no other choice but to kill him. It's not exactly a self-defense, because self-defense really requires that you felt like that person was going to kill you or cause you extreme bodily harm at the time that you acted. That is much more the Ashley Benefield case, so which we'll talk about in a little more in a minute. So in the Benefield case, she was saying he was coming at me. I took seriously that he was going to abuse me because he had done it in the past. In the Benefield case, she said he had never been physically abusive to me, but he had been emotionally abusive and threatening to me so much that I believed he was escalating and he was going to hurt me. And I pulled out a gun and shot him. That's a kind of a different set of facts and a different approach, because they didn't really use, they sort of tried to do a hybrid self-defense and battered spouse. It didn't work for Benefield. It didn't work when they did the initial stand your ground hearing to see whether or not self-defense could be argued and whether or not she had had the right to stand her ground. The court did not find that she had acted in self-defense in that she was justified in standing her ground. And when they brought it up at trial, the jury did not believe that she had been justified in shooting him. So now we have, and that's a Florida case as well. So now we have Sarah Boone. Now, the defense is a little bit different because they're claiming that Jorge had been abusive to Sarah on several different occasions. There were police reports. He was arrested on one account and in one instance. So it is a little bit more, it has a little bit more substance to it. But I mean, in some cases, where self-defense and battered spouse works, there's a lot more, and it's a lot less intentional, maybe. Generally, I mean, probably the most famous case is the one from the 70s. Farrah Fawcett was in the movie called The Burning Bed. And that was a case where a husband had been so abusive for such a long time. And he came home and he was very drunk and he was very abusive and he beat the woman up and passed out on the bed. And while he was asleep, she stitched him by hand, sewed him into the bed sheets, and set the bed on fire. That was a very extreme case, and it was the first case where the battered spouse syndrome was raised. I think the case with Sarah Boone is a little more attenuated. First of all, there's no indication that Jorge was abusive to her on that night. There's no indication that she was afraid for her safety that night. So that's a little bit more difficult to make that case. So interesting, however, I think they're going to have a tough time. I think that, coupled with the fact that she's got him in the suitcase and she's taunting him, is going to be a hard pill for the jury to swallow. So I don't think it's going to get them very far in terms of a defense, but I am glad that James Owen is on the case, and I am glad that she has representation, because I think that it strengthens any conviction. If she were to proceed pro bono and be convicted, I think there would be a lifetime of appeals coming in that case. So I'm glad that she has what appears to be very able, very experienced legal representation. So, back to Ashley Benefield. Her attorneys have filed a motion for a new trial. They say that there has been juror misconduct. It's interesting that once again we are seeing social media encroach into jury deliberations. In this case, a YouTube creator called That Hoodie Guy posted that his sister had smuggled a telephone into jury deliberations and was sending him text messages. And in fact, he posted very specific posts about the jury and what they were finding, what the split was, all of those things, just prior to the jury announcing that they had a verdict. And so they have filed a motion for a new trial on that basis. They also filed a motion for a new trial on what I think is a ridiculous and completely flimsy basis. And that is that in the closing argument, the prosecutor made a mistake and argued that Eric Benefield had been the one who had, oh, I'm sorry, it's Doug Benefield, had been the one who had filed for custody of their child, when in fact it was Ashley. I don't know whether that was a mistake, but it appears that it was, because all the evidence, sorry, all the evidence that it was presented in the case was that Ashley was the one who had filed for sole custody of their child. So what I want to say is closing argument is argument. And the jurors always receive a jury instruction that says closing argument is not evidence. If what is said in closing argument is not what you remember, you have to rely on your own notes and your own memory. So I think that's sort of a flimsy basis to ask for a retrial. But there is a decent basis to ask for the trial, a new trial based on juror misconduct. So that's concerning, and I'm sure that the court will be sorting that part out. Courtney Richins finally had a preliminary hearing last week. And at that preliminary hearing, the judge found that there was probable cause to bind her over for trial. And the judge said that he would set a trial in 2025, May of 2025. So that case is going to move forward. She is still in custody, and there's still a lot going on behind the scenes in the civil cases having to do with her husband's estate. I think she recently had her retained attorney withdraw. Sky Lazaro is her name. She's a very experienced and able defense attorney, and she withdrew for ethical reasons. Now, initially, what Sky Lazaro said was that information in the civil case put them in conflict, and that they had a conflict based on information that had been released in the civil case. But she later then said she had so here is the dilemma when you are an attorney and you have to withdraw from a case. The attorney-client privilege protects the client and precludes you from actually telling the court what the basis is of the conflict that you have to withdraw from. But there are certain sort of circumstances or words that are kind of used to telegraph to the court that you have an unsolvable conflict, that you have a situation where you must withdraw for ethical reasons. And so generally an attorney will go to a judge and say, Judge, I find myself in a mandatory withdrawal situation. That would be the way I would phrase it in my state. Different bars sort of use slightly different language, but that certainly lets the judge know that there is a non-waivable conflict, that there is some sort of either conflict of interest or a conflict with your client that isn't something that can be overcome. Often that is the fact that the client is lying about something and that you are in a position of having to put that fact forward as truth or withdraw from the case. So I suspect that that's what happened. She was out of money So when Sky Lazaro withdrew, she was appointed a public defense team. I think there are at least two other lawyers that are on the case as well. So we're going to see, and I think that was the reason why the court didn't rush to set a trial date, because they really need to get up to speed. One of them did communicate that there may be some pretrial motions filed, so it'll be interesting to see how that moves forward. One of the issues that came up was that Courtney Richins, at least in a in the infamous walk the dog letter, the letter that she wrote to her mother, suggesting what her brother might say if he was deposed, um, included information about the fact that her husband took a THC gummy at night to help sleep, and that they never tested those gummies for fentanyl. So that may come up, and they may request, I'm assuming they're still in evidence, they may request some of the testing be done. The walk the dog letter is very damning, because she's very clearly attempting, through writing a letter to her mother, to get her brother to tell a completely different story about how her husband was going down to Mexico, and when he was in Mexico, he was using drugs and bringing drugs back, and a lot of things that are not supported by any of the evidence. So there's still some discussion about her attempting to tamper with witnesses. So we'll see what happens in that case. There was yet another setback in the Delphi case. You all know Richard Allen is being held in custody. At one point, he was being held in a prison rather than in jail. Although they claimed it was for his own safety, he appeared to be in much more danger in the prison than he ever was in the local jail. He has since been moved back into jail custody, and he is awaiting trial, which is going to start on October 14th. The judge has, at this point, ruled that there will be no cameras in the courtroom. So if you are interested in following that case, you will need to follow creators who are planning to attend. One of the creators that I know is planning to attend is Bob Motta from Defense Diaries. He practices in Indiana, or in Illinois, sorry, and Delphi is in Indiana. And he's already said that he is planning to attend the trial each day. And he will be giving wrap-ups once the trial's over in each day. So, but the defense suffered a big setback today, because Judge Gull, who many people believe is extremely biased against this defense team and against Richard Allen, ruled that her defense team will not be allowed to offer any evidence that a third party could have been involved or responsible for Abby and Libby's death. That means that they cannot bring in the Odinist theory. They cannot bring in any other people. So Ron Logan, who was the property owner where the girls' bodies were found, can't be brought in. And they can't bring up Anthony Schatz, who was I believe, a pseudonym for Keegan Klein, who had been in contact with the girls and was catfishing them. So this is really a devastating development for the defense. It really guts their defense, because they're going to be now limited to poking holes and finding reasonable doubt. Now, and unfortunately, they have a client who made some confessions. There's discussion about whether or not those confessions were done under extreme duress or not, whether they were coerced. And he admitted to being on the high bridge during that period of time. However, One of the things that came up in all of the pretrial information was the prosecution has wanted to make the case that the girls were murdered during a certain time. It's become clear from the medical examiner's records that that is their own speculation, that there is no clear-cut time at which the murders were committed. So it makes it much more difficult for them to say, well, Richard Allen was in the park during that time. It also makes it difficult for the defense to point fingers at other people because the judge has said that evidence doesn't come in. So it really does shoot the defense case in the heart. Because now they're going to be reduced to saying things like, yes, you found a bullet, and yes, it's junk science that you contend that it was worked through Richard Allen's gun. It was an unspent bullet, and there's no real scientific basis for identifying Richard Allen's gun as opposed to any other gun of that make and model. So I know that it's a huge setback to the defense, and they are going to be scrambling to put together a solid defense in spite of not being able to bring in all that third-party information. Just a little gee whiz, there is a case out there called Nevada versus Deborah, I'm not sure, Redden. You might recall that this is the gentleman who was being sentenced in a Nevada court and rushed the judge and leapt over the bench and got a hold of her. He has been accused of attempted murder, and his trial started today. They were doing jury selection. So for any of you who might be interested in that trial, it's going on. And you can probably find it on Law and Crime or any of the streaming services that are offering trial streaming. One of the last cases I wanted to talk about is Dee Warner, because her husband made his first appearance today, so a couple of interesting things came out. One, her brother said that he actually was the person who tipped the police off about the tanks that were on the property, on Warner's property. The court also said that there had been a preliminary examination that the defense and the prosecution both just got transcripts of. Now, I am not entirely familiar with how a preliminary examination works. It seems like maybe it is a hybrid of a grand jury and a preliminary hearing, but I don't know. I need to do a little bit more research on how that works in that state. The parties then, the defense and the prosecution discussed that they intended to get together on September 10th to discuss issues having to do with discovery and whether or not all discovery had been disclosed. They said that they didn't believe they had all of the most recent discovery, probably having to do with the search through the tank and the medical examiner's reports yet. So they asked the court for 60 days, and the judge set the next status hearing on the 30th of October. And the judge, the defense said that they expect that they will be filing pretrial motions. So that case is really just getting underway because he was just recently arrested. So that one is going to be fascinating to follow. In that case, Dee Warner's family believed that he had murdered her, but they couldn't find her body. And the family then went to court and asked the court to declare her dead so that they could civilly to declare her dead so that the prosecution then could prosecute him for her murder. The court did that, but I know we've talked at length about the fact that no body trials are very difficult to prosecute. So it was a real stroke of good fortune that her body was found. It was after he was arrested, but so he was already in custody when her body was found. But it makes prosecuting the case much easier. A case where there's no body always opens up the argument she's not dead. So the fact that they were able to locate her body was huge. Lastly, I want to talk about Adelson. Donna Adelson's trial is coming up on September 17th. The judge was hearing quite a few pretrial motions, including some substantial motions in limine. Now, a motion in limine is a motion for the judge to make an evidentiary decision prior to trial. It's done so that the evidence isn't presented to the jury and then objected to, because, as we all know, it's very difficult to unring a bell. So a lot of times, both sides, both state and defense, will file motions asking the court to look at an evidentiary issue and make an evidentiary ruling ahead of time. There were several of those motions, and there was a motion to dismiss that the defense filed based on the amount of time that it took for them to bring charges against Donna. So the motion to dismiss because of delay was somewhat interesting. The defense alleged that the prosecution waited too long to bring the charges against Donna, and that because of that, some evidence has been destroyed. Evidence that would have been available if the charges had been brought sooner. Specifically, phone records, because the phone companies only keep their records for a year, and SunPass records. SunPass are a pass that you can buy that gets you through toll booths in Florida. Florida has a lot of toll roads, and a SunPass is a little, I'm not sure whether it's a device or whether it's I don't know, but it hangs from your mirror, and it allows you to, it just counts the number of times you go through a toll booth and then charges you the appropriate toll, like at the end of the month. Jen says it's a transmitter. I thought so. It's a little transmitter device that reads the sensors as you go through the toll booths. So there was a SunPass, of course, on Donna Adelson's car, and the question is whether or not she went to Charlie Adelson's the night of the murder. Now, there are text messages that show that she said she was out in front of his house on that night, and that those text messages indicated that she was there. Catherine Magbanowa said that she was told by Charlie that Donna and Harvey had just been there before she got to Charlie's house, and they had brought the money. Catherine Magbanowa talked about the fact that the money was wet like Donna had washed it. So the defense is saying we cannot either corroborate or refute that information because those records are gone. We can't get Donna's son pass, so we can't confirm whether or not she went through toll booths near Charlie's house. We can't do any of those things. And the prosecution is saying we have that information. We didn't get the son passes, although we would love to have them too. But we do have information that puts Donna at Charlie's house at that night. Now, Donna and Harvey said it was because they were driving from South Beach, Miami to Tallahassee to be with Wendy because Danny had just been murdered. However, the prosecution says they were going there, but they stopped at Charlie's on the way and dropped off the money to pay the murder for hire guys, the gunmen. So the judge didn't make any final rulings. He heard a number of pretrial motions, and they are set again to talk about pretrial in the next week, and then trial starts on the 17th. So I thought Donna, for somebody who they all yelled was so frail and so suicidal and all those things early on when she was arrested, she looked pretty robust. She looks like she's been eating snacks out of the commissary, and she looked strong and healthy. So it's going to be really fun and interesting to watch that trial. Knowing what we know about Charlie Adelson's trial and the fact that the same lawyer is representing Donna, I think we have to assume he is going to make the same conspiracy argument that it was really an attempt to extort money. The gunmen were trying to extort money. It wasn't murder for hire. So we'll wait to see what comes of that. That's the last of the roundup that I have, but I'm sure that you all have a lot of questions. I've been seeing a lot of questions starred in the chat. So let me know your questions and we will chat about them. Sorry for my scratchy voice. Hi, Carrie. Hi, Lori. I'm always happy to see you. Did you see Jose Baez called the prosecution out in the last Shanna Gardner court case? Do you think the judge will dismiss? I did see that. And I did see that the judge was not very happy with the prosecution about the fact that it was clear that they had withheld discovery that they were obligated to provide. That said, I don't think that it's reached the point where the judge would dismiss. My impression was that that the judge was sort of like this is your last chance. You better do the right thing and get the discovery to the defense. Jose Baez is a very good lawyer, and I am sure that he is combing through every grain of sand, and I am sure that he is going to call the prosecution out at every opportunity. So I don't think that it has reached the point where they're going to grant a dismissal. I think that you saw a much different situation in the Alec Baldwin case, where the trial was already underway, and it was very clear that the prosecution had just blown the defense off when they asked for discovery that they were entitled to, and that discovery was potentially exculpatory. So I think it was really a very different situation. It is interesting that I read that that the prosecution is, in spite of the fact that the judge dismissed the case with prejudice, meaning that it cannot be refiled, is asking the court to change that and allow them to refile the case against Alec Baldwin. I have absolutely no thought that the judge would do that. I think she was very clear when she made that decision that she had had enough of the prosecutor's shenanigans and she was absolutely not going to allow them to bring the charges again. So I think they're barking up the wrong tree there. So, yeah. Other questions? Hi, Bo Peep. I saw that you had some questions. Thanks for joining us. I saw that you joined us really early before the stream started, so thank you for that. Bo Peep's question is it more beneficial procedurally for Mr. Owen to work as a hired attorney rather than doing the case pro bono? He said his client he said he has clients that accept $50 a month in payments. He accepts $50 a month in payments. I think that's true, and I think that what he said in his interview on Court TV was, I believe that expecting that a client is going to pay their attorney sets up a different set of expectations and between the lawyer and the client, and it also holds the client accountable and responsible. So that was his feeling about coming up with a payment agreement, even if it's a payment agreement that she may never be able to keep because she may never be out of custody again. So I think that that's the case. As to the question about whether it's better to be court appointed or retained, the courts don't really look at whether a lawyer is court appointed or retained. The only issue is whether or not the state can pay for some of the other costs that are associated with the case, like experts and investigators. We know that the state of Florida has already paid Sarah Boone's investigator. The court has already approved those payments. And at different points, the court has already approved mental health evaluators as well. So it will be interesting to see whether or not the state of Florida is willing to continue to fund the fees and costs associated with Sarah's case, even though they're not paying her lawyer. But courts do not differentiate between, and oftentimes judges may not know, other than the fact that they know all the public defenders, they may not know for certain whether a case is actually an attorney is appearing pro bono or appearing retained or appearing as a state appointed lawyer. And it would really be unconstitutional for the judge to make that differentiation or treat the defendant differently based on who their lawyer is. So, but that's a good question. Could there be a conflict of interest if this judge handled Sarah's brother's case some years ago? Do you think Mr. Owen is fighting to get her case dismissed or a plea deal with a lighter sentence? First of all, I don't know enough about the conflict to know whether or not he would be conflicted out for representing a relative. Generally, it isn't a conflict unless Sarah was somehow involved. She was a witness or she was a victim. If it is a completely different case and they happen to be related, that's not a conflict. He did say in court that he would be filing a couple of pretrial motions, which may include a motion for dismissal. I don't think he gets it, but I think that he's having to file whatever motions he needs to in order to make his record for appeal. He did also say that he had discussed plea negotiations with the state and that they were unable to reach any kind of an agreement on a negotiated settlement. So he did have that conversation. Sarah Boone also was able to view all of the evidence that was in the custody of the sheriff. That happened. They were going to have a hearing and require them to bring all the evidence, and then they agreed that they would rather transport Sarah to the sheriff's evidence room and be able to view all the evidence and secure the chain of custody and all of that. So she did report at the last hearing that that happened. And that helps her lawyer be able to sit down and say, you've seen all this evidence, Sarah. You've seen how persuasive it is. So now let's talk about the reality of how we, of how we go forward. So I wish him well. I'm glad she has a lawyer. I think that it secures her rights, but it also protects the prosecution from having the case overturned because she didn't have due process and didn't have effective assistance of counsel. So, that one, I'm kind of anxious to watch that one. That and Adelson. Do you know if the jurors have to vote unanimously for a guilty verdict in Florida? I believe that Florida has passed a law where it has to be as many as 2 or 3 of the jury can vote not guilty, and they can still bring a guilty verdict. I will look that up, but I'm pretty sure that they do not require a unanimous verdict. It could be, however, let me preface this by saying it could be that they don't need to be unanimous to impose the death penalty. Now that I think about it, they may need to be unanimous in the innocence and guilt phase and less than unanimous on the death penalty. But I'm going to look that up for you, and I'll have that for you next week. Let me make a note. Unanimous verdict in Florida. Thinking about another Florida case, the Madeline Soto case is moving along, and he is in custody, and that case continues to be investigated, and his parents have both been interviewed, and it's interesting because it seems like the mother's a little bit more enabling and the father's a little bit more disgusted. But that one is moving ahead. If you are interested in that case, Gisela Kay from Grizzly True Crime has been doing some really good deep dives into that case. So if that's something, a case that you want to get more information on, that'd be a great place to get it. So Adelson and Boone are the 2 cases that are coming up next, and it will be interested to see what happens. Jane Blackbird, this is an excellent question. Why would Donna launder the money to erase fingerprints? I think that's possible. I don't know if she felt like she wanted the money clean so that it didn't have any substances on it. You know, we've heard and read in the media that something like 90% of cash that goes through the hands of bank has some sort of drug residue on it because of it changes hands during drug deals. Often it's used as they roll up a bill and use it as a straw to snort opioids or meth or cocaine. So there often is our residue, drug residue on money. So that may have been a reason why. But it's, for some reason, Donna felt the need to actually wash the money, which is a little bit different than money laundering, where you're trying to cover up the source of your cash. So, but I don't know for sure what she thought she was washing off the money. Good question. Hi, Mary. I apologize if you covered this already. Any updates on Delphi? I did cover it. I'll give you a quick thumbnail. The judge, Judge Gull, who appears to be really in the prosecution's pocket on many things, has ruled recently that the defense cannot use the third party culprit defense, and that they cannot even mention the Odinist theory, and that they cannot mention the members of law enforcement who were investigating that theory. It's a huge blow to the case. As far as we know, the case is going to go forward on schedule in mid-October, and but the defense is not going to be able to raise some of the things that they had concerned. Yes, you might have noticed that my light is fading. I'm going to turn on my ring light. I have really had a hard time managing the light in my office studio because I have this big old window right here, and covering it, putting a blind over it, just doesn't seem to mute the light enough. And then as we get later into the evening, the sun starts going down and the light starts disappearing. So I'm still trying to figure out ways to equalize the light. I'm sure that as we get into winter, it's going to be much less of an issue. So, so Delphi is still going forward, and the defense was dealt quite a blow recently in the judge's decisions. So, should the hiring policies of police officers include a psychological testing of some sort before they can be recruited? Can Farwell be charged for the unborn baby as well? I don't believe he can be charged for the unborn baby. This is a state-to-state sort of law. You know, most criminal law is state law. And it varies from state to state whether a person can be prosecuted when they murder someone who is pregnant for the murder of the mother as well as the murder of the unborn child. I don't believe in Massachusetts that that's the case. And different law enforcement agencies, again, law enforcement agencies differ on how they screen potential police officers, and more importantly, how they monitor the mental health of their existing workforce. We know that police work, first responder work of any kind, is very, very stressful and in many ways very traumatizing. We know that trauma is cumulative, and there are many law enforcement agencies that have mental health workers who are available to police officers and first responders, and they also frequently do what are called critical stress meetings and debriefs, especially in mass casualty cases, in those sort of circumstances. But every agency is a little bit different. The state may be more cognizant of, because they have a bigger workforce and more streamlined policies, they may be more aware of and cautious about the mental health of their officers. Smaller jurisdictions may not have the resources to provide the sort of counseling and the sort of monitoring of law enforcement's mental health that a larger organization may have. So, say the Boston Police Department may have a much bigger and better resourced organization to monitor officers' mental health than a small jurisdiction like Stoughton. It's also true that smaller jurisdictions tend to be more insular and look out for one another and cover each other's tracks. And that appears to be what was going on in Stoughton um, with Sarah. So it really varies from jurisdiction to jurisdiction. Um, it could be that at the state police level, they're required to do psych evaluations and to have a clean mental health bill of health before they're hired. But then a person could easily pass that, go to work for the department, and then because of the stresses and the traumas of the job, decompensate. So I'm not sure that that sort of screening is as helpful as programs that assure that once you're on the job, you are being adequately monitored for good mental health. And I'm not entirely sure that a mental health screening would have turned up Mr. Farwell's propensity to groom a young girl. And that is very much about an imbalance in power in a relationship, and very much about someone using their position almost to foster um, idol worship, hero worship. So there is absolutely no question the 30,000 text messages paint an appalling picture of not just Farwell, but his twin brother and at least one other officer that that he encouraged to be intimate with Sarah when she was very young, very impressionable, and very persuadable. So that's a horrible case. It's almost as bad as the case where the guy who was sorry, I thought I turned off my my I thought I turned off my notification bell and it's pinging there. So um, I think that case is almost as bad as a recent case where a man is being prosecuted for um, sexually abusing both his own child and his stepchildren, and yet the mother was jailed and he's been allowed bail. The mother was jailed for being in contempt of the court's order to allow him to have visitation with the children, even though she knew that he was abusing them. That's a little bit different case, and I've seen a lot of outrage about it, and it really is outrageous. But it boils down to, as a parent, if you violate an order of the court, you can be held in contempt, even if the reason you violated the order is very compelling. I think that in that case, the mom will be vindicated. I don't think she's going to spend a lot of time in jail. I don't think that, but I think that this is one of those custody cases that was so contested that it was often difficult for the judge to really understand what was true and what wasn't. Sometimes in these high conflict custody battles, think Lori Vallow and Joe Ryan, it is really difficult for a judge to sort out what's true and what's not true. And I think that until this guy was actually arrested for the abuse and is being prosecuted, the judge only had her say so. And any experienced judge will tell you that there are many cases where parents make allegations of abuse in order to gain a leg up in the custody battle. So judges often don't take that at face value when it's simply claimed by the other parent. Um, that's tough because there are cases like this one where it actually was true and he actually is being prosecuted. So I think that um, her divorce lawyer, her custody lawyer is going to be able to make a case for her the necessity of her violating the court order, and I think that um, cooler heads will prevail going forward. So good questions tonight, guys. Let's wrap up here pretty soon. I'll just take a couple of other questions and then we'll say goodnight. Your thought on Owen saying that George's brother was arrested for the stabbing murder of his girlfriend recently? Well, I think that came out on court TV. I don't think that it came out in court. And I think that a judge would say it's not particularly relevant. That sounds to me like, propensity evidence that a judge would absolutely keep out because, judges keep out things that would lead a jury to find that this person had a propensity for violence. Um, it certainly is a little bit attenuated to say, well, his brother has a propensity for violence, so surely George must have too. I don't think that it's remotely relevant and very prejudicial. So I don't think that a judge would allow it in. I think it was sort of a gee whiz that he dropped on Vinnie Politan in the court TV interview. So, I think it may have been a case of him saying, hey, George was no angel and neither is his brother, but I don't know that it has any real relevance. It's just kind of sensational. So good questions, y'all. Bopi, before you close, I just wondered if you're familiar with an old case involving Charles Cullen, the nurse responsible for hundreds of deaths. I recognize the name and I remember the case. And if you would like me to, I will look it up. He's certainly not the first nurse responsible for patients' deaths. It's kind of hard to understand that dynamic. Is this a case where a nurse is really being merciful? Is this a case where this is a person who has severe psychiatric issues and it is a form of serial killing? These cases are not that unusual. We saw a case a couple of years ago out of England with a female nurse in the neonatal ICU that was responsible for the deaths of fragile babies. And we certainly have seen it before. I'll look the case up and report back because I remember the name and I do remember that there was an allegation, at least, that he was responsible for a number of deaths. So, good questions. I want to say thanks to everybody for being here. Thanks to everybody who has pre-ordered the book. Thanks to all of those who got an early digital copy and are ready to post reviews. I appreciate it so much. If you post a review and drop me an email with your mailing address, I will send you swag, including a signed book plate for your book and some other goodies. So please let me know and send me a screenshot of the post. I want to say thanks to everybody who joins us every Wednesday for a little bit of chat and a lot of talk about current cases and the law. And I always want to thank Jen, our moderator, for her able support. Don't forget, she's also the administrator for the Good Lori Facebook group if you're interested in that. And I know that we have a newsletter that has been somewhat dark lately. I mean, meaning that there haven't been any in a while. And that is because I've been really busy with moving and getting the book finished and doing publicity and all those other things for the book. But if you have a subject that you would really like me to do a deep dive, or a case that you would like me to do a deep dive, please email and let me know. I do know that I have promised you that I will do a deep domestic violence dive, and I will absolutely do that. It is an issue that is near and dear to my heart, that I feel very passionate about. I literally cut my trial teeth doing restraining order hearings early in my career. So it is something that's very important to me, and I definitely owe you that. But let me know if there's anything else that you would like me to address in the newsletter. And this is a good time to remind you that we are still making quilt squares for Kay and Larry Woodcock, who are J.J. Vallow's grandparents. The quilt looks like origami cranes, and origami cranes have a special meaning in Japan. People fold origami cranes in memory of someone, and often folding 1,000 origami cranes is said to give a person who has passed peace. Now, we're not doing 1,000, but we are putting together quilt squares. The instructions and the address and the pattern, the link to the pattern, everything is in the show notes. You can use a black background and any color for the crane and send them my way, and we will be assembling them into a lap-size quilt for Larry and Kay. There's the new address. I do still have a few Justice for Tylee and JJ wristbands that we made available before and during the trial. I still have a few of those. And if you are a follower and would like a signed book plate for your pre-ordered book, please drop me an email and I would be happy to send you one. So with that, I'm going to say good night, everyone. Thanks again, Jen, for all your help. Thanks for all of you joining us tonight. We'll be back on Wednesday, I think, but let me check. No, that's right. This week, we will be back on Wednesday. Sorry, had to think about it for a minute. But there are some dates where I won't be here because I will be doing book signings. So, but I'll let you know those in advance. So we will see you next week. Have a great week. Take care of each other and enjoy the last weeks of summer. Good night.